Welcome to Looking at Legal Stuff. Today we have 4 hearings in a case with a couple where mom refuses to respond to any of dad's pleadings because she's decided she doesn't want custody of her daughter anymore, so she doesn't need to. She says her daughter is a disrespectful liar and she wants nothing to do with her. She says she refuses to have her daughter in her home and subject herself and her family to the lies anymore, and she won't be responding to any custody paperwork. Dad's lawyer says Mom's husband has gone so far as to shoot at the process server when they tried to serve her with documents. Mom says he was trespassing. What does the judge think? Let's find out.
All right, let's go to Timothy Nicholas and Brianna Earlywine. I know, Mr. I'm getting feedback from your, there you go, that's gone now. Is Miss Earlywine here? So, Mr. Nicholas, you brought a motion for contempt, and that needs to be personally served on Miss Earlywine, and I haven't seen a declaration of service. Do you know if that's been done?
It's been done, yes.
Been done?
I didn't serve it. I didn't bring it back to the courthouse, Your Honor. So we kind of come to a resolution, and it was basically the visit stopped because I dyed my daughter's hair. So when I went and filed for contempt, we finally came to a resolution that the only way I can continue my visits is if I went down and got a hair follicle test. That goes back a year. It was negative for everything. I sent them certificates from my drug school and my classes. So I've gotten to see her for 2 weekends. We sat down about being better co-parents for her, but I just want it to be known that I'm trying really, really hard to clean the mess up that I've made. And that regardless of her having a new husband or having full custody that I agreed to for my daughter, I do have rights to her as a parent. I don't want to be that any of that to be taken away just because they don't like something that I did. Her mother didn't like the hair being dyed. I understand that. We're just I'm working really hard to get back to where I was at with my entire family, because I have 2 other children involved, and the power over me kind of thing, and just being able to take away my visitations like that because
We're all frozen. That's
Internet connection.
what's
Yeah.
that?
When our internet gets popped up a couple times that it's unstable.
Can you hear me now?
There we go. Mr. Nicholas, why don't you repeat what you just said? We all froze for a little bit.
The visit stopped because I dyed my daughter's hair. So when I went and filed for contempt, we finally came to a resolution that the only way I could continue my visits is if I went down and took a hair follicle test. I went back a year.
Right. And I did get that part. Are you looking at putting together some sort of temporary or permanent parenting plan that would guarantee visits?
We already have a final parenting plan established, and that's why I went down and filed the contentment paperwork.
Right. So are you now going to start following that plan, or is
It was my visitations. The reason of me not seeing my child was because I dyed her hair on my weekend.
right?
And I went months without visitation, and I was just trying to get back on track to where I could see my
Okay.
daughter and have my daughter back. With
So do you want to strike today's hearing? Wow,
Yes.
we're frozen. Do you want to strike today's hearing?
Yes, I just wanted it on record that I'm doing all the steps that I needed to be doing, and that I have rights essentially. So that was my main point on filing the paperwork. But yes, I would like to strike it.
Okay, all right. I will strike it, and if you need to bring this to court again, you can do that, okay?
Thank you so much, Your Honor.
Thank you.
All right, number 3, 4, and 5, early wine, or Nicholas v. Early Wine, 15-3-00226-5.
Net matters ready.
All right, do we have Brianna, Early Wine?
Your Honor, I didn't anticipate her being present today. We were just able to effectuate service on Sunday. So it was going to be my request to set this matter over. I did file that proof of service yesterday and I did provide you a bench copy. I don't know if you have that in front of you, but there was some dramatics, to say the least. Our process server was shot at the last time he attempted service. So at this point, I am asking for the immediate restraining order to be continued. If you want to set this matter over, 2 weeks is probably best, maybe 3, because we're probably going to have the sheriff's office serve her, given the incident this past weekend.
We can set it to the 27th if you like.
Okay, I can prepare an order extending, and then I will just send that over for Your Honor's signature ex parte.
Yeah, that's fine. And just
Okay.
put not appear for her.
Okay, I can do that. Thank you, Judge.
So I'm going to call number 5, 6, 7, and 8, 15-3-00226-5, Nicholas v. Early Wine.
That matters ready.
And Miss Talishog is here. I don't go by Early Wine.
All right, according to the record, we have to at least call the name Early Wine because that's still the record of what it is. So we have so at this point, I do not have any responsive pleadings. So I need to know what Ms. Bliss.
And Your Honor, I have not received anything from Ms. Polishog either. I did receive the sheriff's proof of service from the most recent extended restraining order. And Ms. Polishog was personally served on the 4th of February. So at this point, I'm asking the court to adopt my requests as they've been presented.
Is it Tolishog? Is that
Talishog.
okay?
Actually, I wasn't personally served on the 4th. I was served just not too long ago by a sheriff at my work, but not the 4th. The first time around, somebody trespassed actually on my property. We have a gate and even signs that say no trespassing, and I have videos as well. But yeah, somebody attempted to first serve me prior to the first court, wasn't able to make it due to work, and then again served at work. I don't feel a need to respond. A lot of this is lies. I told my daughter once her father was stable
so
and able to take care of him. I'll just cut it short then. I don't want custody. I don't want anything.
I'll just mute you if you don't stop when I ask you to stop.
Excuse me, I've already stopped.
You do it again, I'll just mute you. So the problem is that at this level of court 1, I believe that Ms. Bliss, I saw a service on February 15.
Yep, that's when I got served.
Your Honor,
let's make this simple. I don't want custody. So whatever needs to be done, I'm not going to subject myself nor my other child I have here to my daughter's behaviors. Her physical behaviors to my son, and
I asked to talk to Ms. Bliss,
so.
not you at the moment. Ms. Bliss.
thank you, Your Honor. And the February 15th was the service of the order extending the immediate restraining order. Ms. Tolshog was personally served by drop service on February 4. There was an affidavit from Mr. Gilman indicating he attempted service, went to the home, dropped the documents, and then was later shot at by Ms. Tolshog and or her husband. So at that point, he was no longer willing to continue attempting to serve her. So we were forced to utilize the sheriff for the order extending the immediate restraining order. However, she was served with the initial documentation on the 4th.
So Ms. Tolshog, and I apologize if I'm saying that incorrectly. Based on the fact that I see that there was proper service, that it's been at least 11 days since the second service, that I will be signing off on these documents. I did review the files and record. Based on the files and record, the court does find adequate cause. Further, the court does believe it is appropriate to keep the restraining order in place. The proposed parenting plan is approved. The father shall enroll the child in school within 72 hours of entry of the order. And then, Ms. Bliss, are you still requesting a guardian ad litem?
At this point, given the fact that she's not contesting, I don't think one's necessary at this time.
Okay.
No, I'm not contesting anything. Like I said, I'm not going to have her in my home with behavior she has, not only to me, but to my other child in this home. Where
I've
she's
heard it. I've
physical
ruled
and sexual
enough. What I need to
behavior
know
to-
at this point, Ms. Tolshog,
Talashog.
I'm sorry. I don't mean to keep misstating it. So I need to know if you approve via Zoom on the orders.
I don't approve any of these orders. I don't agree with what's being said in there. The only thing I agree with is that he can have her. I want nothing to do with her. I wish her the best life over there. They
Okay.
can deal with all the chaos.
All right, I will be signing off on the orders.
Thank you, Judge.
That concludes this matter. Taken care of. Number 1 on the docket, 15-3-00226-5, Nicholas v. Earlywine. Let's see, we have Miss Bliss.
Yes, Your Honor.
Anyone else here on that matter?
I believe my client was present at least at one point this morning.
Miss Talashog is here.
Okay,
Formerly known as
I
Earlywine.
see Tim Nicholas. I ask that you turn your videos on, please.
I don't know how.
That's my client, Your Honor. If Your Honor has no objection, I don't mind
That's
if you just
fine.
step off.
All right, and we have Miss Earlywine under the docket. That's what you're called, and so I need to refer you to as that, just to keep a clean record. All right, so Miss Bliss, go ahead.
And Your Honor, this is my request for a motion in order for default. Ms. Earlywine or Talshog was present at the temporary orders hearing. She has not filed any responsive documents despite being at that hearing. I've since attempted to resolve this matter. She's not responded to any of my correspondence. So at this point, the only way forward essentially is to make a request for default or set the matter for trial. I think procedurally, the fact that she hasn't filed any sort of response warrants this request today.
I did actually try to call you 2 different occasions. Most recent one was on Saturday. I don't feel the need to file anything. Again, I've already stated that I do not want to continue any communication, contact, anything with Phoenix due to my own family's safety, mainly my son. The disdain that she has for me and my son, I just don't feel is a healthy relationship to continue. So again, I don't feel the need to respond. I've already stated that at the last court hearing, after I'd stated that somebody tried to attempt to serve me after they illegally trespassed on my property.
So you need to understand that if you do not respond in the legal proceedings, I'm going to be signing off on a default, which means that your ability to have a say in the outcome of this case goes away. You've lost that ability. And so by not responding, is that still your intent, not to respond in writing to the petition?
Yeah, I'm not responding to any of that. Like I just stated, I've already stated I don't want to continue any contact, communication, relation, anything. I don't feel the need to respond to lies. I could respond with a whole bunch of pictures off of her phone of stating abusing and bruising that were downloaded from Safari. Again, it's just lies. I don't respond to lies. I'm not. No.
Right.
Continue how you please, no.
All right, Ms. Bliss, I don't think there's any choice then but to sign off on the default.
Yes, Judge, and I did prepare final orders for purposes of today's hearing as well. I had asked that you sign those as well, so this matter can be completed.
So it looks like you've been referred to as Miss, is it Tolshog?
Polishog.
Polishog. In these papers, first I signed off on the order on motion for default. In the final order and findings on petition to change a parenting plan or custody order, Ms. Polishog, that's the name that's on here. Are you willing to put approved via Zoom, or are you not going to?
I'm sorry, you were cutting out. I'm in a vehicle. What was that?
I said on the final papers, it has a place for your signature. Do you want me to put approved via Zoom, or do you want me to put refuse to sign?
I'm not signing anything. I already stated that. Whatever you choose to do is what you choose to do. My signature is not going on a packet of lies.
So I've signed off on the final order and findings on petition to change parenting plan or custody order. And on the parenting plan, again, signing off on that order. Signing off on the child support order. Worksheets. All right, so again, I've signed off on the order on motion for default. The final orders as submitted. Putting refuse to sign for Ms. Polishog, and that takes care of that matter.
Thank you, Judge.